Court is now in session. Please be seated.
Good morning. I'm Justice Shin. I am joining Justice Han and Justice Grant for one case today, Commonwealth versus Christopher D. PRAIRIE, number 2024 P528. Counsel, I'm glad you both made it in safely. You may begin.
May it please the court, and thank you, Your Honors, for allowing me to talk to you about this case. My name is Dan Ciccarello, and I represent Christopher PRAIRIE. As you know from reading my brief, the issue was whether or not there's sufficient evidence to prove these OUI and negligent operation, and also a corollary is that the motions for required findings should have been allowed. And the reason why I say that, Your Honor, is because for several factors, major factors, and there's some minor ones that I'd like to get to. The first one is that my client did not drive unsafely. If you go by the police officer's testimony, he did not speed, he did not weave, he did not drive erratically. There were only 2 instances in which the police officer had said that he had driven negligently, and that was, as we know, going across the yellow line. The first one and the second one, which was more dramatic, in which just by a mere, he was able to swerve back and not hit the police car that was coming at him. Just my client's luck that he did that infraction when when a police car was coming in. The cop had braked and dropped all the food that he had purchased. The question, though, is that for the second time in which he caused that dramatic situation, he had claimed that he had sneezed, and it was an involuntary action. It was a reflex action, and that I would suggest to you...
Apologies, counsel. I just noticed the clock has not started.
I'm sorry?
The clock has not started. Okay. I believe you've been speaking for about 5 minutes, so...
Well, yeah, a couple of minutes, sure, certainly. I'm at your command. You can tell me when to stop anytime. In any case, getting back to that, sneezing is a non-intentional reflex action, and I would suggest to you that this is a general intent crime, and that if you look at my brief, I cite Commonwealth versus Gunter and Commonwealth versus Van Winkle, in which they have to show that there was some type of intentional action. I would also not mention in my brief.
Counsel, I'm sorry to interrupt, but couldn't the jury have disbelieved the evidence of a sneeze and have determined that the swerve was for another reason?
Well, Your Honor, I think that the jury could have believed that, but I don't think that it was enough to be able to go in front of the jury, because I don't think that there was sufficient evidence in the rest of the case to show that it should have gone in front of the jury. And I think that the judge should have allowed the motion for required findings because they wouldn't have been able to show that it was an intentional act. So I would suggest to you that there's, not in my brief, but there's a Supreme Court case that I had seen, United States versus Bailey, talking about knowledge being corresponding with the concept of general intent. And I would suggest to you, Your Honor, it's as if I tripped and I fell into you or I fell into somebody, that certainly would not be a battery, because it would have to be an intentional action. Or if I'm stretched and I hit you, happen to be behind me and I just happened to hit you, that certainly was not an intentional act. The other reason why I say that, Your Honor, to back up the issue about the point that you had brought up in my answer, was that the other indicia of OUI were not present. For example, Your Honor, they used the Commonwealth had used the argument that when the policeman had turned around his car and went after my client with the lights flashing, it took 200-300 yards to stop. And I'm not a mathematician, but I would hope that judicial notice that if you do the math, going 60 miles an hour for 200, 300 yards is only about 6 to 8 seconds. So it's not really
But
that.
there was a turn, wasn't there also a testimony that your client drove straight, the lights were on the cruiser behind him, made a turn, went down the street about 200 or 300 yards down that street, and so there was it wasn't simply taking some time to pull over.
Well,
Was the import of or could have been the import of the testimony. Would you agree?
I apologize for interrupting you, Your Honor, but that may be true, but the issue, there's no testimony about whether or not it was safe to stop on the major road, and so we don't know. Just the idea that he took 200-300 yards to stop is just an indication. They're trying to show, well, he was trying to outrun the police, or he wasn't being cooperative, or some issue associated with being drunk. And then when he was stopped, he got out of the car without any incident, without swerving, without falling. Then he does the field sobriety test. And the field sobriety tests, I would suggest to you, were not indicative at all that he was under the influence or had diminished capacity. If you look at the first one, which was the 9-step turn around and come back, he did make a couple errors doing that. However, on the next 5 times, he did it successfully, according to the police officer. I would suggest to you that in alone shows that he doesn't have diminished capacity, because if you were saying, well, if he didn't do the first one correctly, then that would have been. Then he would certainly had diminished capacity, but he did the next 5 correctly. Then the one-handed leg stand, the one-leg stand, pardon me, he certainly had problems standing on one foot, and he told the police about that. And his statement was corroborated later by the mother, who had testified that he had these issues with his leg from an accident that occurred 15 years ago or something, 15 or 16 years ago. But in any case, they asked him to stand on one leg and to count, and he counted correctly. He didn't sway for balance. He didn't have really any problems with it, except for the physical aspect of it. I would also point out to Your Honors that he was only tested for physical agility, but not for cognitive issues, which he certainly showed that he was able to, by counting correctly and also by obeying the rules 5 times in the first test. Next, he was cooperative and coherent, and when he was booked, he admitted, the booking officer had admitted that that Mr. Prairie answered questions correctly. He didn't sway back and forth. There was no issue about him. He didn't swear. He didn't argue with the officer. I have to admit that the testimony of the police officer said that he was smelt of alcohol and had bleary eyes, but I would suggest to you that that's not really the indication of whether he had diminished capacity. So we take the testimony about his driving, in which he did go across the double line twice, but the second one I would suggest to you is easily understood as being a sneeze, as being an unintentional act. And that is corroborated by the police officer had testified that that's what my client had maintained from the beginning of the stop until he was booked. As a matter of fact, I think there was a testimony that he spoke on the telephone to his friend and said, yes, I got stopped because I sneezed. This is not, everything taken all together, I would suggest to you, does not show that he diminished capacity. If there's no further questions, I'll rest on my brief.
Thank you very much.
Thank you for your attention. I appreciate it very much.
Good morning. May it please the Court, Rosella L. Corey for the Commonwealth. I would just like to preface my argument with an apology for my tardiness this morning and thank the panel, including Justice Ditkoff, Attorney Ciccarello, and the Clerk's Office as well for being so gracious and accommodating to me.
Could we reset the clock, please? Thank you.
The Commonwealth maintains that the evidence placed before the jury in this case, when considered in the light most favorable to the Commonwealth, was sufficient to convict the defendant of both operating under the influence and of negligent operation of a motor vehicle. As this court is well aware, the court does evaluate the sufficiency of the evidence under the Lattimore standard, which is taken in the light most favorable to the Commonwealth. Additionally, in a case such as this, where conflicting inferences are possible from the evidence, it is for the jury to determine where the truth lies, and that is from Commonwealth versus Woods, 466 Mass 707, page 713, which is a 2014 case, and Woods itself was quoting Martina, which is a 1992 case, and Wilborn, which is a 1981 case. So it is long established in the Commonwealth that where there is a conflict, potentially, in how one can interpret the evidence, that is for the fact finder to determine. Again, the Commonwealth's position is that the evidence was sufficient. The Commonwealth did not need to prove that the defendant drove in an unsafe manner, but does need to prove the diminished capacity to operate safely. That being said, there was direct testimony from the police officer in this case that the vehicle the defendant was driving swerved over the line not once but twice, the second time resulting in a near head-on collision, which is sufficient both for negligent operation actually endangering the public and for to raise a suspicion on the officer's part that alcohol might be involved to justify the stop. And through his further investigation, he did make the determination that an arrest for OUI was appropriate at that point. The evidence, again, sufficient to go to the jury when looked at in the light most favorable to the Commonwealth. If there are no questions from the panel, I am happy to rest on my filings.
No questions.
I don't see any.
Thank you so
Thank you very much. Thank you both. The case is submitted. We are going to take a very brief break to reconstitute the panel, so counsel for the next case can get set up.